Vincent J. Russo, Facebook Live, for this event, COVID-19, Why Estate Planning is So Important, the Essential Documents. Today, I'm going to focus in on how do you have a plan of protection? What should I have? How do I get the documents I need? And what are the next steps I should be taking? So we're all staying at home, doing our social distancing, and making sure that we're taking care of ourselves and our families. At the same time, there are steps you could be taking to make sure that from a legal standpoint, you're protected as well. So I'm going to go over some of the key planning documents that can really make a difference in protecting you and your family. The first one I want to focus in on is in the area of healthcare decision making. So many people are going into the hospital, as we all know. People are at home, not feeling well because they have the virus. So it raises that question, how do healthcare decisions get made? Who makes them if I'm not able to? So the starting point is you're in control. But if you're not able to make those decisions, then what happens? How do I make sure that end-of-life wishes are carried out, God forbid? And how do I access my medical records if I'm homebound? So there are 3 documents, healthcare directives, that can help you maneuver and navigate through these issues. The first is a healthcare proxy, the second is a living will, and the third is a HIPAA authorization. So let's first talk about the healthcare proxy. You control all healthcare decision making, but if you're not able to, then who steps in? Who has the right to make those decisions, especially if you're in the hospital and incapacitated? The starting point is for you to have control. And the way you can have control is by having a healthcare proxy, where you appoint an agent to make healthcare decisions for you if you're not able to. And you can name a backup agent. In that proxy, you can say you want organ donation if that's your choice. You can also put in a note as to whether you have communicated with your agent your wishes regarding extraordinary life-sustaining treatment. Now, if you don't have a proxy, then there is a law in New York called the Family Healthcare Decisions Act that will have a pecking order of basically family members who can step in. I strongly urge everyone to have a healthcare proxy. You can download the proxy from the New York State government website and follow the instructions. There are formalities that you need to take when signing the document. Or you can contact my office and we're happy to make it available to you. I'm also concerned about if you have a loved one who already is incapacitated and is not able to sign a healthcare proxy. You may want to consider whether you should commence a guardianship proceeding and have yourself appointed legal guardian of that loved one. So that may be a really important step to take. Now, when it comes to extraordinary measures at end of life, New York presumes that everyone wants all treatment under all circumstances. So you control that decision, but if you're not able to, there needs to be what's called clear and convincing evidence. So we suggest, if you want to make it clear what you would or would not want in that situation, that you have a living will. So the living will are instructions to the agent under your healthcare proxy. You can download a living will form from the internet, or here again, you could contact our office and we could talk to you about these healthcare directives. Now, let's say you're laid up at home and you need access to medical records and you're not able to do that yourself. Well, the HIPAA authorization form is a document that allows you to authorize individuals, more than one if you want, to be able to access your medical records. That'll make it easy for families to kind of coordinate and work together in making sure healthcare records and decisions are made as a family. So HIPAA authorization avoids finding out that the doctor won't release the medical records because the paperwork isn't correct. This form will allow you to be able to quickly gain access to medical records by having a family member help you or a friend. Now, we've talked about healthcare decisions, and I think that's the lead. We all want to be safe, but we know so many individuals right now are facing some very serious healthcare decisions. We also know that we're being impacted financially. So you're in charge, you're paying your bills, you're managing your assets, and that's fine. But what happens if you're laid up? Who can step in and do that for you? No one can unless they've been legally appointed by your having a durable power of attorney, naming an agent to be able to do that, or a legal guardian appointed by the court. So you don't want to be in a situation where you're in the hospital and your bills, your utility bills aren't getting paid. You don't want to be in the hospital trying to manage your own assets, especially if they're in the stock market right now with the market going up and down, and everybody's trying to figure out what to do or just sit tight and not do anything. So this power of attorney is really important. It's essential to make sure that you name the right people, individuals who can step in. You can name more than one at a time, or you can name one after another. There are a lot of choices here. It's a fairly complicated document in New York, so you really should have legal counsel to help draft that document and then arrange for it to be properly signed. We'll talk more about how we get these documents signed in a few minutes. Now, I'm doing a daily check-in on Facebook, and on Monday, I tackled the issue of wills, and I raised a few questions. Can I change my will by writing on the original and signing it? The answer is no. You cannot amend a will in that way. You need to have either a codicil or a new will replacing the old will, and it has to be signed with qualifications such as you need 2 witnesses and you need to be in the presence of each other. So having an attorney oversee or supervise the signing is really important to make sure it's done right. If I don't have a will, another question that comes up is, can I handwrite one and sign it along with 2 witnesses? And the answer there is no. That's the general rule in New York. There are a few exceptions, but holographic wills are not generally permitted. So then the question arises, what if I don't have a will? What happens? Well, New York will then determine who inherits your assets. And there's a pecking order, basically following spouse first, and then, or spouse and children first, and then closest blood-related family members. So your will allows you to control who inherits your assets. And I just want to mention New York State is on that list if you don't have a will. So how do we put these documents in place? We've talked about the healthcare proxy, living will, HIPAA authorization for healthcare, the power of attorney for finances, a last will and testament. Well, we are in challenging times right now. It's very difficult, but it can be done. Just the other day, the governor amended his essential business order and now is allowing attorneys to be able to supervise document signings in their law firm offices. So we are making ourselves available in that way. But there are other ways that we can get these documents signed. We could mail the documents to you with instructions on exactly how to sign those documents with the proper formalities. We could do what's called a drive-up signing. Either a client driving up to our office parking lot and we'll come out and have you sign the documents from your car, or we could drive up to your house and arrange for a document signing. Now, there's been a real concern regarding those in hospitals and nursing homes and assisted living facilities, because now they've tightened up the rules on who can visit. Here again, though, there are ways to get those legal documents signed if you have a loved one in a hospital, in a nursing home, or an assisted living facility. So I would say on this, reach out to your elder law attorney and discuss the different ways that perhaps you can arrange to have the documents signed. One of the things that the governor did just a few weeks ago was to authorize e-notarizations. So we have a temporary order right now that allows the notary to use video conferencing or FaceTime to see the document signed. And then there are certain steps that have to be followed. But basically, if that document is signed in that fashion and then sent to the notary the same day, the notary can then notarize the electronic document. So this can be done, for example, for powers of attorney, real estate deeds. It also can be done for an affidavit, a self-proving will affidavit that the witnesses typically sign after the will is signed by the testator and the witnesses. So we're doing our best as elder law attorneys and as estate planners to make sure we're available to help you. Now, there are some solutions to this issue of, well, if I do have a will, how long will it take for the will to be probated? And what probate means is that if you pass and that will has to be filed in the surrogate's court, and the reason is the will's not valid until the court approves it and approves who the executor is going to be. And that could be weeks generally or months. And now, with the situation we're in, it could be even a longer period of time. So with a will, even though it's really important that it controls how you leave your assets and who you appoint as executor, here are some of the challenging questions. How do I access the assets to pay for a funeral and the living expenses for loved ones who survived me? Who's in charge of my estate during that period? So these delays are really concerning. So there are alternatives. I think the best one to talk about is the Revocable Living Trust. So this is a document that basically replaces the will. It allows you to name a trustee to manage the assets in that trust. You can be the initial trustee, and when you pass, the successor trustee steps in without any court proceeding, and whatever assets are in the trust, they have immediate access to. So they could pay for the funeral, pay for ongoing living expenses, manage the assets, distribute those assets more quickly than perhaps if there's a will involved. So a revocable living trust can be signed, set up by you. You can be the initial trustee if you'd like. And then you have to put the assets in the trust for it to really work for you. So that would mean you have to change the name of your bank account or your brokerage account or the deed. So there are some additional steps and paperwork that would be involved. But if this is a concern of yours right now, steps could be taken immediately to get assets into that trust, at least a bank account into that trust, so that the monies would then be available to take care of those immediate needs. Another alternative would be to name a beneficiary of your bank account or your brokerage account. So there's a beneficiary designation form that you can get from the financial institution and name individuals. That's a secondary choice in my mind because it does allow access of those assets by the beneficiaries, but there are no protections built in that can typically be built into a trust. Like what happens if the beneficiary is a minor or they're disabled, or what happens if, God forbid, if they should pass more or less at the same time you do, then what happens? Or perhaps you want to leave the assets in a way that it's held in a trust until certain ages are reached, and then it's paid out in installments. With a beneficiary designation, it's quick, it's simple, it's outright to those individuals without the protections I'm mentioning. You could also own assets joint with right of survivorship, which means the joint owner becomes owner of your bank account or brokerage account if you set it up that way. So these are some alternatives. It might be that you want to make sure you have your will and then maybe one bank account joint with right of survivorship or pay on death so that the funds are there and that will work well together. I would say speak to your attorney and talk about the options, see what makes sense for you, and then act accordingly. Now, I'm getting a lot of questions about trusts beyond just the Revocable Living Trust. So we're going to do another Facebook Live in 2 weeks where I'll just do the whole presentation on Revocable Living Trusts, Medicaid Asset Protection Trusts, and Family Protection Trusts. So there are lots of different types of trusts that could really fit nicely in your overall estate plan in terms of protecting you and your family. I am getting a lot of questions about asset protection. What happens if I can't pay my debts during these trying financial times? Will creditors be able to get at all my assets? And the general answer is, of course they will. Whatever assets you have will be subject to creditor claims. Could you take steps to protect your assets? So there are a couple thoughts here. One is that if you own a business or real estate that you're renting, you should have that asset, that business asset, in a limited liability company, an LLC, or a subchapter S corporation. It's a way of limiting the exposure in a situation where if a claim was made in connection with that asset, that business, the creditors could only get at the assets inside the company and not go beyond that and attack your own personal assets. So that would be step one, especially those who may own multiple rental properties. They should be placing them in individual LLCs. Second would be to take some of your assets that you're looking to protect and place it into an irrevocable trust. Now here, there are going to be restrictions that are going to come into play. and you really would want to talk to your attorney about the pros and cons. With regard to retirement accounts, I'm getting questions there as well. Your 401k and your IRA are creditor protected in connection with the account owner owning that account. So I have an IRA or a 401k plan, I'm protected. If it's an inherited IRA, for example, where I passed away and now my beneficiaries own it, I hate to tell you this, but there's no creditor protection in that situation. Here again, there are steps you could take with some additional planning to protect those assets for beneficiaries who are the recipients of an inherited IRA account. Lots to think about. So let's kind of go at a higher level here and think about the big picture. What happens if you do not have a plan? I think the consequences are incredibly serious. They're real. I think you lose control over your personal life. You lose control over healthcare decision making. You lose control over your assets, financial decision making. It might result in you losing part or all of your assets. It may be that you will not be able to access long-term care services through Medicaid because no one's there to be able to qualify you. These are really serious concerns that we all need to take into account, especially in light of the virus and what it's doing to all of us. So, what should I be doing? One, take stock of where you stand. Take a look at what planning you have done. Take a look at your assets. And then think about, is this the plan that works for me and I'm totally comfortable and I'm protected? Or do I need to fix the plan? Or if I have no plan, create the plan. Then the question is, how do I create that plan? Well, here I would say retain the services of professionals. There are healthcare professionals who can help you with healthcare issues. There are investment advisors that can help you with the finances. And then there are elder law attorneys, special needs attorneys, estate planning attorneys. We do all of that in our law firm, and we can step in and help you figure out what that plan should be, and then help draft the appropriate legal documents and get it implemented for you. So with that, I think I'll stop here at the 25-minute mark and just take some questions. So let me see here. I'm having a little trouble with my mouse. Do you have, let me move this. Okay. Do you have to do an entire will redone if you need to do a basic amendment of 2 lines removed? So the answer there is you can do what's called a codicil, which is an amendment document to the trust, and then you can outline the change you want to make. We generally prefer to do a new amendment, a new trust, as opposed to a codicil, because then when you go to probate your will, you're only probating 1 document and not 2 documents. And for our clients, we have those documents in Word, and it's actually quicker for us to do a new will than an amendment. Okay, how long does a power of attorney stay in place? Coming from Hillary Topper, my good friend Hillary. How long does a power of attorney stay in place? Do you need a new one every few years? Great question, Hillary. So a power of attorney is effective immediately unless you have what's called a springing durable power of attorney. which does not become effective until you no longer have capacity to manage your affairs. So I would say 99% of our clients do a standard statutory durable power of attorney. It's effective immediately, and it will last for your entire lifetime unless you revoke it. So you can revoke it and do a new one. And so at any time you change your mind about the provisions or who you are appointing, go ahead and make the changes by just revoking your durable power of attorney and signing a new one. Now, that doesn't mean you should take the power of attorney that you have, put it in a drawer, and forget about it. Because over time, there may be changes in the law, as well as the changes I just mentioned in your circumstances, where you would want to do a new one. So the last big change we had in the law was in 2010. So anyone who has a power of attorney prior to 2010 should have it reviewed. And anyone after 2010, take a look at it. Every year, you should review all your documents and decide, are they in order, or have I changed my mind about who I'm appointing or how I'm leaving my assets, who's making healthcare and financial decisions. All right, I'm not seeing others in the queue at the moment, so I want to thank everybody for checking in with me today at Facebook Live. There are a number of activities that we're getting into over the next week or two to be helpful to all of you. First, let me mention that the materials for today's presentation and last week's presentation will be posted on my website at vjrussolaw.com before the end of the week. The easiest way to get the latest information while we're going through this period of staying at home and dealing with the COVID-19 virus is to go to our website, vjrussolaw.com/COVID-19. Julie, do we need the .com after VJ Russo? Yes, so it's vjrussolaw.com/COVID-19. No spaces. All right. I am going to be doing another Facebook Live event tomorrow, which will also be a Zoom event at 2 p.m. on how can the Paycheck Protection Program help me. So for all the small business owners who desperately need support, financial support, check in tomorrow. How can the Paycheck Protection Program help me? 2 p.m. I'm also continuing to do my daily check-ins on Facebook. Please join me. Let me have your comments and give me your ideas on topics that you might want me to talk about. With regard to the law firm, we are open by appointment only. We are available to help you in any way we can. So we're doing office meetings. We're doing video conferencing. We're doing telephone conference calls. Any which way that we can help you help you in regard to the things that you're worried about, the things that are a problem right now in your life. So we're there for you. We're available. And I look forward to addressing any issues or questions. Don't hesitate to call 516-683-1717. So I'm wishing you all to be safe, you and your families. Make sure we're doing our social distancing. Let's take care of each other. And have a great day today.